Good morning. Today we will begin our discussion with the seller's obligation to disclose defects in the property to the buyer. So let's picture it. You are wanting to purchase a house and you found what you think is the perfect property. And so you call up your real estate agent and you go on a beautiful sunny day and you're walking around and it just seems like the perfect place. You're falling in love with it. But what you don't realize is that every time it rains, the roof leaks, right? The seller knows this because they've lived there long enough through enough downpours to realize that these leaks occur. The issue that we'll be dealing with today is whether or not the seller has an obligation to disclose to you, the buyer, the fact that this roof leaks. And you may be surprised to find out that historically the answer is no. The rule of caveat emptor stated that it is the buyer's obligation to determine whether or not the condition of the property meets their satisfaction. And if they fail to do sufficient inspection or fail to uncover a defect on the property, then in fact they assume the risk. Caveat emptor, buyer beware. So the first case that we're going to talk about today, Stambovsky versus Ackley, deals with a case out of New York where we begin to see a breakdown of the old common law rule of caveat emptor. So as you can see here, there's a picture of the house that's at issue here on the board. So let's start with Mr. Martin. Who are the purchaser and who's the seller in this case?
Okay, the purchaser is going to be Stambovsky, and he's also the plaintiff. And we have Miss Ackley, who's going to be the defendant and the seller.
All right. And where's this property located?
It's in the village of Nyack in New York.
Okay. And is that important? Is that an important fact in this?
Well, I believe the court alludes that it is because Mr. Stambovsky is a outsider. He's from New York City.
From New York City. That's right. So we have the little village, and we have a New York City person coming to buy this house. And so, why? So they entered into a contract to purchase the house, right?
That's right.
All right. Why are they trying to get out of the contract?
Well, Stambovsky believes that the house is haunted, according to reputation in the community that he finds out later. Finds out later,
after they've entered into the contract,
correct?
All right. So the next question is, what does the seller want? Well, first off, what does the buyer want? So they've entered into this contract. He finds out it has this reputation for being haunted. What does the buyer want here?
The buyer wants the equity remedy of recession.
Okay.
Rescission, excuse me,
that's
not
right.
recession.
Wants to get out of the contract.
Correct.
All right. So what does the seller want in this lawsuit?
She specifically wants specific performance.
What is that?
That is the enforcement of the purchase agreement that she and Mr. Stambovsky entered into originally.
That's exactly right. She wants to force him to go through with this contract. And we talked about last time that specific performance is a unique remedy in the world of real property because every piece of real property is unique. And courts can actually force someone to go through with the contract. Okay, now let's move on to Mr. Mann. Mr. Mann, what arguments are the buyers making that they should be able to get out of the contract?
Well, they argue that the seller had an obligation to disclose to them that the property is haunted.
All right. And what is the rule in New York at this time? Is it caveat emptor? It's caveat emptor, right? So they're going to have to get around the traditional rule that says seller has no obligation to disclose this, right? Absent some sort of, in other words, the seller can't lie and the seller can't intentionally cover up the defect, neither of which happened here. They just didn't disclose the presence of these ghosts. All right, is the property actually haunted? So in other words, we're complaining about the ghost on this property, but can we say that it's actually haunted?
Well, the court holds that because the sellers created an impression, like through the publications and so on, that the property is haunted, they are prohibited from now saying that it's not haunted. The court even goes so far as to say that the house is haunted as a matter of law.
That's exactly right. It's the only time you'll find in a case where a court actually says, as a matter of judicial notice, we're going to say that this is a haunted house. So it's not even something that the sellers can dispute, right? They can't build it up as haunted and then come back and say, no, we were just kidding. All right, very good. So Mr. Dawkins, what makes this case different from the ordinary duty to disclose case that we see?
In an ordinary case, the buyer would allege that the seller did not disclose a physical condition, such as a leaking roof. Here, the buyer is alleging the seller failed to disclose a non-physical condition.
That's exactly right. Does everybody see that? That in our ordinary case, it's like the one I started off with. The situation is such that the physical condition of the property, there's a defect that the buyer doesn't know about, can't discover upon inspection. But here it is the fact that the house is haunted. All right. So now that we have that laid out, what did the court ultimately hold here? Was there a duty on the part of the seller to disclose this condition?
The court held that because the seller had created the condition by reporting these apparitions, that the house is haunted and a buyer would not be able to discover the haunting from an ordinary inspection. You shouldn't require purchasers to call Ghostbusters every time they purchase a home. In this case, the reputation for being haunted decreased the value of the property, and the buyer was entitled to get out of the purchase agreement.
Now that's an interesting point that you're making. And that is something that we'll deal with later on, and that is the question of, did it decrease the value? And I would ask you this personally, would the presence of a haunting or a ghost decrease the value of a property that you wanted to purchase?
To me personally, no, because I think you could turn that into ghost tours, but again, it probably just limits your marketability to who would be interested or who wouldn't be interested.
Okay, so this is something we're going to have to address is, how do we determine whether or not it impacts marketability? Okay, well this is a fun case to deal with because it really shows a breakdown. Remember, New York was a caveat emptor jurisdiction, and it shows a beginning of a breakdown of the rule that the seller has no obligation to disclose. And what we'll do now is move on and talk about other situations and see how far the seller's obligation to disclose defects on the property really go. So, very good.